The next matter to come before the court is the State of Ohio versus Melvin Prince Jr. Good morning.
Good morning, Your Honor.
It looks as if the state has waived oral arguments, so you'll have 15 minutes to present your oral argument.
Understood. Thank you, Your Honor. May it please the court, Donald Gallick on behalf of defendant appellant Melvin Prince. Unless there's any discussion needed on the statement of facts, I'd like to go immediately to the three assignment of errors. And for reasons that will become apparent very soon, I'd sort of like to go on them in opposite order. And that's because assignment of error 3, obviously there's an Ohio Supreme Court case, State versus Anderson. It's dispositive. Probably not much to discuss on assignment of error number 3. Assignment of error 2, I think there's a little more in depth. However, rule of evidence 404A is pretty clear. Usually we're arguing 404B, but here we're arguing 404A. You can introduce character witnesses. The rule specifically provides for it. The trial judge told the pro se defendant he couldn't. So that's unequivocally a misstatement of law. The only question becomes, is that error reversible error or is that harmless error? And I argue that it's reversible error because the case was not an overwhelming case. And we'll get into assignment of error 1 as far as the state's theory of the prosecution. But the jury came back obviously on one not guilty on the firearm specification, but did come back guilty on the felonious assault. I asked this court to consider that some evidence that the case against Mr. Prince was far from a slam dunk case where this court might say, oh, it's harmless error. Even if he had someone come in and be as a character witness, it wouldn't have made any difference. You would have had the same verdict. Well, there's certainly a colorable argument that you could say, had he had a character witness that was apparently waiting out in the hallway, who could say, hey, I've known Melvin Prince however long, he wouldn't shoot anyone, he's not a violent guy. It could have persuaded the jury into coming back with 2 not guilty verdicts. So that's part of the basis that I would say that the violation of 404A is not harmless error, it's reversible error. Although I certainly have to point out, I know it's not telling this court anything it hasn't seen 1,000 times, more and more criminal defendants think I don't need an attorney, I can be a pro se litigant, I understand all this, and had Mr. Prince had trial counsel running the trial, we probably wouldn't be here discussing this because an experienced lawyer might have said, Judge, 404A is pretty clear, we're allowed to put on character witnesses. Can't do anything about that now. I wouldn't say that's invited error, but the trial judge misstated the law and there doesn't seem much question about that. Moving on to assignment of error 1, which I think has a lot more depth that might need discussion, and that is the issue of a bill of particulars. And I want to point out the state's response brief in the first couple paragraphs agrees that criminal rule 7E, yeah, it has mandatory language. Upon request, a bill of particulars shall be furnished. But then the state's brief goes in and says, well, but there's discretion. And so the trial court has discretion, the prosecutor has discretion, and it's abuse of discretion standard. There's no law that I found, and apparently there's no law that the state found, I didn't see it in the brief, resolving this conflict. How do we have mandatory shall issue language in criminal rule E and in a provision of Title 29? It's mandatory, but you have discretion to disregard it. So that's inherently contradictory. So what is the law of Ohio? I don't know, but I would ask the court to go to the plain language of the rule and the plain language of the statute, and if it shall be furnished upon request, then that means it must be furnished upon request. It seems rather redundant to say it that way.
What was the request?
Well, there was a bill of particulars that was filed, and again, you have a pro se litigant not doing it the best way. He didn't know what a motion to compel was, but there is a point, and it's in the transcript, it's cited somewhere in the brief. Hey, how come I didn't get my bill of particulars? Now the trial prosecutor, he did file a response saying, I don't comply with that. There's a written in the record about 30 days after the request for a bill of particulars, the trial prosecutor files a response, I don't do that, we don't do that. And I think he might have had cited some authority. I know there's opinions coming out of this court that says, well, if it's open file, or if you adequately know what your charges are, then you don't have to pay attention to that. Prosecutor expanded that a little bit and just said categorically, I don't do that, I don't do bill of particulars. And Mr. Prince probably should have filed some additional paperwork to try and force that issue. He didn't know how to do that. But once again, you have something where the law is clear, just like in assignment of error 2, it's not followed, and what is the remedy for that? Now, I cite various cases from this court where you talk about, it could be harmless error, you knew what the charges were, you knew exactly what you were accused of. In this case, we can show prejudice. Mr. Prince goes in saying, they're accusing me of shooting someone. I didn't shoot anyone, that's why I want to go to trial. If in the indictment it said, you're charged with complicity to commit felonious assault, if in the opening statement you're charged with complicity to commit felonious assault, we could have an entirely different litigation. And I cite some part of the trial transcript where the sergeant is being questioned, and I can't remember if it was director or cross-examination, but it's like, isn't it true the co-defendant had gunshot powder residue on his hand? Isn't it true that the co-defendant shot him? The gunshot residue, that doesn't mean anything. That doesn't mean that Prince didn't shoot him. And then there's another point where the sergeant is being questioned. When you interrogated Mr. Crenshaw, didn't you say, we know you shot him? And the sergeant says, yeah, I accused Crenshaw of shooting him. But that's just a technique. I know he didn't shoot him. I know Prince shot him. I was just falsely accusing Crenshaw to try and get him to point the finger back at Prince. So for the first half of the trial, the whole state case in chief, we know Prince is the shooter, he's the shooter, he shot this guy, you gotta convict him. Then it turns out that that case was a little weak. Then the prosecutor said, you know what, we can use complicity. We can use complicity, so maybe he didn't shoot him, he's still guilty. If you had a bill of particulars, you wouldn't be in that situation because you would have something filed on such and such date, Prince did, using a firearm, shot the victim, or in the alternative, on such and such date, he assisted the shooter, he was complicit, he aided and abetted, something like that. You don't have a bill of particulars. Yes, Your Honor.
We have case law forever that says that the state need not include the complicity language in the indictment. Well,
and Your Honor, and this is the problem, because the court has said that, but then the court has also said don't worry about providing a bill of particulars in most cases. So that's why I cite this all these U.S. Supreme Court cases saying you've got a real due process problem here. Because on one hand, you don't have to mention complicity in the indictment per this court's precedent. You don't have to mention it. You don't have to file a bill of particulars. You have someone, and let's forget that he's pro se. Let's say he's the most experienced trial attorney in the world. You walk into trial, I wonder, are they saying that my client shot him? Or are they saying he helped to shoot him? Or what are they saying he did? Well, we'll tell you in the middle of the trial. And that's how it works here. And the prosecutor, there's even a point in the citation where I cite to the transcript where the prosecutor says, we don't have to do that here. We can just come up at the last minute in the middle of the trial and say we can use complicity. Is that a due process problem where you're walking into a jury trial and your client says, hey, what am I really being accused with? Well, I don't know, but we'll find out at some point in the middle of the trial. I mean, the whole point of a bill of particulars and procedural, it's procedural and substantive due process. That what am I being accused of? What is this trial going to show? What is a to-wit in the bill of particulars? Well, we don't get a bill of particulars. What does the indictment say? Well, the indictment doesn't have to say exactly what I'm accused of. It might be complicit. They might be saying you're complicit. They might not. We'll find out by the end of the trial. Is that a due process concern? Is that something, forget the Ohio statute with the mandatory bill of particulars language or Criminal Rule 7. Is this a federal constitutional issue? When I'm in the middle of trial, I don't know what I'm accused of. Whether it's a pro se person or someone who is an experienced trial attorney, you don't really know necessarily what the whole prosecution case is until you're in the middle of the trial. And the other thing is, we probably have a lot of trials unnecessarily in this jurisdiction because if you had a bill of particulars and you say, look, here's a bill of particulars, client. Okay, they're not saying you shot this guy. They're saying you drove him away from the shooting and threw his clothes away. If they prove that, you're going to get convicted. Oh, okay, maybe we need to plead this case out. Mr. Prince, you can see from the transcript, he's like, I'm going to win this trial. They're saying I shot someone. I've never shot anyone in my life. It's going to be apparent not guilty verdicts. The jury comes back not guilty, apparently didn't think that he had any firearm in his possession, but he gets convicted presumably of complicity to commit felonious assault. Had all that information been in the record prior to the trial date, this case might have resolved.
Well, the state says that the information, all the information was in the record because unlike most cases, here, the transcript from the grand jury proceedings was provided to Mr. Prince.
Well, and that's certainly unusual. And certainly you could say, gee, did Mr. Prince, even understand how to go through that and everything? But again, I don't know if it's good to base precedent on, you don't have to furnish a bill of particulars if you get the grand jury transcript. I mean, that's going to be a fairly unusual circumstance. But again.
But if we're talking about, prejudice to him, it makes it somewhat of an uphill battle, doesn't it?
It does. It is, but I think in a case like this, where you come back with a split verdict, and where Mr. Prince is confused, and you say, well, he's confused because he doesn't have any trial experience. Certainly this court sees more and more pro se cases, and I'm sure this court sees many appeals where you say this case never should have gone to trial. This isn't necessarily, we don't want to put a burden on the state. We don't want to put a burden on the government. It's going to take away some of their power. This is actually something that could help everyone if we just followed the rules, we just followed the mandatory language in Criminal Rule 7 and Title 29. Here's your bill of particulars. They're not accusing you of shooting anyone. They're just accusing you of driving the getaway car. That's something I think in a lot of other cases a lawyer would be able to show you in black and white. This is the bill of particulars. This is exactly what you're not being accused of murdering anyone. You're being accused of throwing a shirt, in a river. Oh, I did that. Yeah, I did that. Okay, well, we better work this case out rather than go to trial. But because you have case law that says we don't have to file a bill of particulars, we don't have to put complicity in the indictment, we don't have to tell you any of this until the middle of the trial, a lot of defendants go in and they're blindsided. And they come in, and I've had trials myself where the defendant in the middle says, well, I thought they said I was the principal offender. Well, I did too, but now it looks like they're dropping that and they're going to a complicity theory. Is that a due process problem? And I know there might be case law from this jurisdiction that go the other way on that. But that's why I cited some U.S. Supreme Court cases, because if you can go in, if a prosecutor can say, I'm really going to charge him with complicity, but we're not going to put it in the indictment, I don't have to. Not going to file a bill of particulars, I don't have to. Don't have to mention it in my opening statement. I'm just going to wait and see how it goes, and if I can stick him as the principal, great. If not, I'll switch in the middle of the trial to complicity. Is that a due process problem? It's common occurrence in this jurisdiction, and I think this would be a good case to clarify exactly, what the state's obligations are under Criminal Rule 7. The Title 29, I think it's 2945 provision. I don't have the precise statute in mind, and also under the due process protections in both the federal and the Ohio constitutions. Unless there's any other questions, I would like to thank the court for its time.
Thank you very much.
Thank you, Your Honor.
We will make certain that you receive a copy of the opinion, and as you know, we post it on the Ohio Supreme Court website.
Thank you very much, Your Honor.
Thank you for your presentation.